It's most fitting that this evening we are going to be talking about the state court system, where often justice is sought and hopefully at least sometimes achieved. Tonight, introducing our speaker, Lincoln Caplan, is Chapman Chair in Law, Professor Robert Spoo, who had Professor Caplan as a professor at one time. Professor Spoo, like Professor Hager, is a greatly admired and truly beloved professor and part of the TU community. Please welcome Professor Bob Spoo.
Thank you, Dean Enseroth. And while I'm still beloved, let me take a selfish moment to plug, before I get into the really main topic of tonight, plug a conference that's coming up that I will be hosting. It will be a copyright conference called How Long? Copyright Duration in the 21st Century. That will be the end of this month, October 29 and 30. I will have 10 terrific scholars visiting from all over the U.S. and Canada. Should be a great event. We'll have more specifics out soon. Well, it's my pleasure to join Lynn in welcoming my friend and indeed former teacher Lincoln Caplan as the 19th annual John W. Hager Distinguished Lecturer. Link is the Truman Capote Visiting Lecturer in Law at Yale Law School. With a BA and a JD from Harvard, he has been a journalist with and a contributor to, among other prestigious periodicals and media sources, The New Yorker, The New York Times, and the U.S. News and World Report. He was editor and president of a new journal for legal current events called Legal Affairs from 2000 to 2006. When I first came to know Link, which was right around the time that he was founding Legal Affairs, it was as a student at Yale Law in an innovative course that he taught on legal writing. It was not the kind of course in legal writing that we ordinarily think of. The manufacture of documents that seek to persuade a client or a judge or a litigation opponent or a government agency of the rightness of our legal analysis. Instead, Link wanted us to develop the skill, often hidden in the thickets of legal learning, of making important legal topics, legal affairs, lucid and living for the ordinary reader, a reader not necessarily professionally connected with the law, but one who might look to the intelligent media for substantive, even-handed, narratively alive encapsulations of the law in today's world. Link taught, urged, even demanded a kind of engaged lucidity that could be found in the Supreme Court reporting of, for example, Anthony Lewis, a figure that Link has written about. But the really challenging thing about Link's teaching, both its point of ignition and its flashpoint for us, was that he expected this kind of reportorial vivacity from law students, budding lawyers with, if they learned their trade, a blossoming prose style of erudite, legalistic argumentation. In his courses, Link, in a sense, seeks to nip that blossom in the bud, to mix floral metaphors outrageously, and to get law students to think beyond the jargonistic traditions and the shop talk that we teach. This means that he asks his students to step outside the role of lawyering and to look on the law as a process, a phenomenon, an event that ought to be comprehensible and fascinating to ordinary, intelligent readers. Link Caplan's own writing has embodied these ideals. His books are major contributions to vivid discussion of the legal affairs of our time. For his book entitled Skadden, Power, Money, and the Rise of an Empire, Link embedded himself, before that term was widely used in journalism, with the world-famous law firm Skadden, Arps, Slate, Mayer, and Flom, where he observed anthropologically and later wrote about the culture of American lawyering, its greed and opportunism, but also its capacity for contributing substantially to important things like public interest lawyering. In Up Against the Law, Affirmative Action in the Supreme Court, Link bravely took on the evolution of affirmative action law by the Supreme Court in our country and showed the ambivalence and tentativeness which have characterized much of the court's approach, in contrast to the way that affirmative action has developed in other walks of American life. In the 10th Justice, the Solicitor General, and the Rule of Law, Link documented the critical role of the U.S. Solicitor General in our legal system and the disturbing trend toward politicizing that office, which represents our federal government before the Supreme Court. In essence, Link has spent his notable career seeking to locate and to address the common reader, in the sense that Samuel Johnson and Virginia Woolf imagined the common reader. Johnson wrote more than 200 years ago, "I rejoice to concur with the common reader. For by the common sense of readers, uncorrupted by literary prejudices, after all the refinements of subtlety and the dogmatism of learning, must be finally decided all claim to poetical honors." Link has rejoiced in and written for the ideal common reader, one with common sense, free or as free as possible from the distorting pressures of party and ideology, and the obscurity and dogmatism that is often the unfortunate byproduct of legal education. Tonight we are privileged to hear Lincoln Caplan speak on the title of his talk, "The Fade Out of American Justice, the Nation's State Court Crisis." Please join me in welcoming Lincoln Caplan.
Thank you very much to the Dean. I was so enjoying what Professor Spoo had to say that I almost forgot that I had a talk to give. Let's start in California. Let's start in the California Supreme Court in San Francisco. And let's focus on a case in which the legislature has sued the Secretary of State and all the other high officers in the state. The issue is that a referendum has passed in which the good voters of California, the land of the American dream, have voted to limit the terms of the state legislators. And to really emphasize their point, they have significantly limited the budget of the legislature. And this is, on the one hand, a fight between the people and their representatives, but on the other hand, it's a fight between the legislator and the court. And you should listen to this story with a sense of foreboding. The voters have passed a referendum which they called the Political Reform Act, and its purpose was to restore a free and democratic system of fair elections by limiting the power of incumbency. And the court has responded. The Chief Justice, writing for a large majority with only one dissent, has said that it's the court's, quote, solemn duty to jealously guard the precious initiative power and to resolve any reasonable doubts in favor of its exercise. So this is what a state court at its best does, right? It interprets the state constitution to resolve a serious dispute, and it's playing its essential role in the American constitutional system. So to put this in perspective, let's just go for a minute to Washington, D.C. And we're on the steps of the United States Supreme Court, and we're looking up above the bronze doors in letters that are so large that they're riveting: equal justice under law. As Americans, we pride ourselves in being a rule of law country, and we think of the United States Supreme Court as the most hallowed place where justices say what that means and they enforce that rule. And it's an article of faith in this country that the path to justice is through the courts. First through this court, next in particular through the federal courts like the 10th Circuit, of which Oklahoma is part, and then the federal district courts, east and west and north in Oklahoma. Those of you who have taken or taught or practiced in federal courts have probably heard of a scholar named Henry Hart. And Professor Hart, with Herbert Wechsler, his colleague, wrote a book that many consider the most important legal textbook since the Second World War, called The Federal Courts and the Federal System. And what they said at the beginning of the first edition of this casebook was that we pose the issue of what courts are good for and what they are not good for. And the book explores which institution of government, whether federal or state, whether the legislature or the executive branch or the courts, whether a trial court or a court of appeals, is the best place for resolving a legal dispute. And in particular, the book concentrates intently on what federal courts are good for, and importantly, what they're not good for. And the negative is just as important to Henry Hart and Herbert Wechsler as the positive. They presumed the broad authority, the reliability, and really the vitality of the state courts. Here's what Henry Hart wrote about them. The law which governs daily living in the United States is a single system of law. It speaks in relation to any particular question with only one ultimately authoritative voice. So the state courts, in his view, have great and immensely valuable reservoirs of underlying law. And these reservoirs are available for the resolution of controversies for which otherwise there would be no law. So Hart's view of state courts is admiring, but as important, it's urgent. His view of the federal courts was really a view of restraint, that the courts should be very careful about what cases they took or didn't take, and should be very cautious about expanding that authority. And the important point here is that that conviction depended on the constancy and the trustworthiness of state courts, those immensely valuable reservoirs of underlying law. And measured by the numbers of lives affected by cases, by the parties involved, there is absolutely no question that state courthouses most often matter in our country's system of governance. In 2012, the federal courts resolved around 330,000 cases, if you exclude bankruptcy cases. In 2010, which is the last year for which there are good statistics, state courts took in around 100 million cases, and if you put aside the traffic cases, they resolved around 50 million cases. Utah, with less than 1% of this country's population, decided 3 times as many state cases as all of the federal court cases combined. Day to day, without question, state courts affect the lives of far more individuals than federal courts. The state courts matter deeply in the American system. So let's go back to California to see what happens in that dispute about the referendum. A fight breaks out about the budget of the legislature, and the upshot of that fight is a 38% reduction in the legislature's budget from one year to the next. And the legislature, showing at least superficial respect, reads the court's opinion very carefully, and the opinion says that the basic and fundamental structure of the legislature as a representative branch of government is left substantially unchanged, and the legislative process should remain essentially as previously contemplated by the state constitution. Okay, so that means that the legislature still has the power to cut the budget of the state court system. And guess what? That's what the legislature does. And how much does it cut the budget by? 38%. So state lawmakers are especially peeved that the Chief Justice's majority opinion described them as an entrenched dynastic bureaucracy. This is a really nasty brawl, and it goes on for some time, and eventually what happens is they reach a compromise around a 2.5% reduction, but the clash dramatizes the plight of state courts across the country. So let me summarize what this story means to me so far. When the California Supreme Court rules on a state constitutional matter, it is a co-equal branch, and it has the authority and the confidence to speak to the executive and the legislature about the meaning of the state constitution. In hearing the referendum case and many others, the court exercises that authority. And from its point of view, it is fulfilling a constitutional obligation about the access to justice that the California Constitution requires it to give everybody, including the legislature challenging a referendum. And it's one of 40 states that has a constitutional clause that makes that guarantee. But when it comes to money, to make that access possible, the other branches of government in California show the courts no such respect. They treat the courts just like the Department of Motor Vehicles. In fact, from their point of view, they are the Department of Motor Vehicles. Mm-hmm. They deserve no special deference in setting their own budget, and the legislature believes it can do what it wants. In California, the land of the American dream, the court has as little clout as it does across the country when it comes to this kind of process. So if this fight in California isn't ringing a bell to you, it's because it happened 25 years ago. Proposition 140, which contained the term limits and the budget limits, was on the California ballot in 1990, and it passed. And the case of the legislature versus the Secretary of State et al. Was decided the next year. And I start there to emphasize that this issue about the situation of the state courts has been with us for a generation. You may not have noticed, or you may have noticed and then stopped paying attention to it, but it has been a critical, unrecognized story in the decline in American democracy for a quarter century. From the mid-1990s until 2007, the American Bar Association found that when it looked at this issue, other parts of government fared relatively well, but not the courts. In 2003, this became of such sufficient concern to the ABA that it put together a commission to look at this, and that commission warned that it was no longer the case that the court's status as a co-equal branch of government was protecting them from deep budget cuts. In 2004, the ABA's House of Delegates took this on and made a series of recommendations about what should be done about this, and then the issue fell in the back of their minds as well. But the Great Recession of 2008 and 2009 made this serious problem truly a crisis, and the ABA was again moved to put together a commission to address this issue, which it called, without any hyperbole on its part, the Preservation of the Justice System Task Force. And after holding fact-finding hearings across the country, the task force filed a report in 2011, which it called Crisis in the Courts, Defining the Problem. Those of you who are attending this lecture under semi-duress, that is, taking it for CLE credit, have that report, and no doubt you've read it carefully and taken notes, but for the rest of you who aren't recalling it, let me give you a flavor by reading a couple of the early paragraphs in the report. The courts of our country are in crisis. The failure of state and local legislatures to provide adequate funding is effectively, at times quite literally, closing the doors of our justice system. At the same time, Congress has reduced its support for both the federal courts and other programs that directly and indirectly support our justice system at the state, county, and municipal levels. Sadly, the courts are easy prey for draconian budget cuts because they lack the power to tax to support themselves, and hence are at the mercy of legislative and executive branch political priorities. At its most extreme, this has led to constitutional crises where judges are forced to sue the legislative and executive branch in an attempt to obtain even the most basic level of support. The writers of those words are not journalists who regularly resort to hyperbole on opinion pages. They're not even legal scholars who have been goaded to amp up their prose a bit in order to get attention to serious thoughts in the cascade of writing that's out there. These words were written for the most part by the dean of the Florida State Law School, and on behalf of the task force led by Ted Olson and David Boyce, super lawyers better known for their advocacy for same-sex marriage, but who spent more time on this issue than they did on that case. The deep budget cuts in 2008 and 2009 led states to lay off judges and other courthouse personnel, reduce hours, and surrender really essential capacities of state courts. In those years, 45 states cut their budgets dramatically, with courts in most of the states losing 10 to 15% of their budgets. And at the same time, the downturn flooded courts with thousands of new cases dealing with property foreclosure, credit card default, and other problems rooted in economic hardship. The extreme downturn boosted the demand for court services, and the decreased supply and increased demand created huge delays, glaring deficiencies, basic denials of access to justice, and really to justice itself. California in those years cut 1/3 of its court staff. It removed bailiffs from all civil courtrooms because it couldn't afford them. It didn't have the budget to develop a new electronic filing system, so when judges were hearing civil cases, it was usually the case, not the exception, that a major document or two on which the resolution of the case depended just wasn't in the file. And judges had difficulty managing cases, let alone deciding that. And whether it was in civil or criminal cases, there were never enough interpreters. So many cases got held over again and again and again because a key party couldn't be understood. Things got so bad that if you got a traffic ticket, which led to the suspension of your license, the earliest you could get a hearing to try to get it back was a year. And while things were bad in California, they were worse in many other states in the country. When judges talk about this subject, they like to talk about how draconian the budget in Georgia was, where, I kid you not, the line for pens and pencils was stripped out, so judges had to supply their own. Over 2 years, that court system lost 25% of its budget. Criminal cases regularly took more than a year. There were many courthouses that just stopped hearing civil cases. And the system to practitioners and to parties felt like it was beyond crisis and was no longer working. When you write a piece of opinion journalism, your editor is very happy when you include a paragraph that might be called the "to be sure" paragraph. So this is my "to be sure" paragraph. There are judges in the United States, in many states, who were heroic in this period. They worked to keep order and calm and clarity in their courtrooms. In particular, they worked very hard to try to figure out what the law is that was applicable in a particular case with a set of facts, and they were especially concerned about taking care of parties who were not represented by lawyers because that number soared during this crisis. In landlord-tenant cases in most states, 100% of tenants represented themselves. In family law cases, the average has been around 75%, but in some states upwards to 90 and 95%. And with those challenges, judges worked hard to do their jobs. So to be sure, this was not a subject that could be described simply in polemical terms. But that wasn't the norm, and it isn't the norm today. The norm is understated chaos and widespread confusion, with judges and the relatively few lawyers in state trial courts talking with each other and often trying to cram in a lot of learning in the few minutes before the judge is supposed to decide the matter. And for many people with problems that bring them to court, the system provides something that looks a lot like arbitrary justice if it looks like a form of justice at all. The ABA report in 2011 explained all of the major consequences, the adverse effect on public policy when criminal cases had to be put off again and again. So judges either had to warehouse defendants who have been charged with a crime or let them out without an assessment of their dangerousness. And because judges couldn't hear domestic cases where they were needed, the judges were often not able to give protective orders with very bad consequences. The ABA focused on the adverse effect on the economy because the cost of budget cuts, which were sometimes called savings, were much less than the cost to the local economy. It turns out that the Los Angeles Superior Court system is the largest in the country with 600 courtrooms. And to deal with budget shortfalls of $80 million in 2009, up to $140 million in 2012, the court ended up firing about a third of its court staff, which not surprisingly led to about a third of courtrooms being closed. And the total economic effects by one account of economists in Los Angeles alone amounted to about $30 billion in losses to lawyers and others who provide legal services, but also in cutbacks in investment by people whose businesses were held hostage by a case that wasn't resolved, and it was too risky for them to make the investment they wanted to. And most of all, there was the adverse effect on people who depend on state courts to resolve family matters, enforce anti-discrimination laws, settle disputes about renting an apartment, buying a car, or some other basic life transaction. One of the things that was most striking about the ABA report was the effort it made to identify solutions to the problems with the National Center for State Courts and the Kennedy School of Government at Harvard. For example, one of the hardest problems is how you think about adequate funding for a court system other than in subjective terms. And so there was a lot of discussion about trying to create some metric that could be used across states, workload of judges, or degree of difficulty of workload of different kinds of cases. There was a lot of focus on increasing efficiency and cutting waste, in particular by having much more widespread use of technology. And at the time, I went to the hearings in New Hampshire. I read the transcripts of the hearings in other places in the country. For people who work in state courts and who care about them, this seemed like a watershed. It seemed like a new beginning. It seemed like the moment when finally the problem was being recognized and evaluated, and it was in the first in a long-needed and exciting set of steps towards finding solutions. So 4 years has passed since then, and this invitation to give this lecture gave me an excuse to find out what's happened from 2011 till now. And the short of it is that 4 years later, there is no state court system in the country that believes that it has adequate funding. 37 state court systems reported increased or steady budget allocations, and almost all of those said with relief rather than pride that their state systems were functioning better than they did 5 years ago. But few of them have restored services to the level they were at before the crisis. 41 states say they've reduced services and expect that reduction to continue. 10 say they've delayed or reduced the number of trials. In general, the only thing that a court system can trade in a political negotiation about money is access to justice. And that's the one thing that it's responsible to provide. So it has nothing to trade, and the conflict about adequate funding continues to limit that access across the country. The result, it seems to me, is a barely audible but constant embattlement of court systems, and the almost continual erosion of authority. The problem is about money, but it is much bigger than that. More fundamentally, it's about the legitimacy of courts in the American system of governance. Daily, this is a retail problem. Each failure to allow an individual or a family, a business, a civic organization to have a day in court delivers the clear-cut message that the legal foundation on which America is based has become optional and really superfluous. Lawyers continue to pat themselves on the back on Law Day. Chief justices continue to say this crisis threatens the reliability and the integrity of their court system, as if the problem still remains in the future, as opposed to being very well documented for decades and certainly in the past 5 years. For each frustrated, disappointed, or ignored American who has failed to have his or her day in court, that's what they're going to remember about the rule of law, that it is threadbare, dysfunctional, an embarrassment, a very sour joke. What they will remember about their most direct and important dealing with government and with democracy is that it is a mess. Yearly, this is a wholesale problem. The annual State of the Court speeches by Chief Justices insist that it's a privilege to represent a co-equal branch, but much of the time they know that that equality is a fiction. When we focus on the U.S. Supreme Court, especially now, we often talk about it as if it's a political institution, because there are 5 justices who are appointed by Republicans and 4 appointed by Democrats, and there's a clear difference between the conservatives and the moderate liberals on either wing of the court. What's striking about the state court problem is that it is not like that at all. It's either nonpartisan or very bipartisan, because legislators of both parties have treated their court systems like the Department of Motor Vehicles. And it's tempting to think of this problem as a decline in service that requires more patience on the part of citizen consumers and an acceptance by them of lower standards, but it is much more fundamental than that. The ABA report concludes with this short paragraph: when there is a general sense of order and justice, the court systems are taken for granted. When they begin to fail, faith in the entire system of government deteriorates. Strong, effective, and independent justice systems are a core element of democracy. Even the most eloquent constitution is worthless when no one is there to enforce it. There are plenty of people, judges, lawyers, people with status, people used to be being listened to, who have done as much as they can to call attention to this crisis. They have studied its consequences, they have told us in detail about them, and they have proposed how to begin to solve them. But as often happens with major issues of law and justice, the conversation about the crisis has largely happened among judges and lawyers and others under the umbrella of the legal profession, and it has not had much effect on politics or on state government funding or on how we think about the role of state courts. Journalism about the crisis has been limited, and it has to be said, ineffectual in raising public awareness or promoting useful solutions. In many states, as the ABA report alluded to, there is a case to be made for a lawsuit challenging the unconstitutionality of the underfunding of the courts. There's a case to be made, in fact, and some scholars have made it, that inadequate funding is a violation of the federal Constitution's guarantee of due process. But no state court has wanted to take this on in a big way. When New York State did, it was about a very limited amount of funding for judges' salaries. And because the risk is that they lose by winning. Which just takes us back to the California case. If they get a court to agree with them, they will have made enemies, especially if they're term-limited enemies, for the duration of the service of those legislators. What's striking now, looking at the unfolding of this drama over the past quarter century, is how much time and effort state courts have expended based on a deep commitment to their essential role in our democracy, and how, at the very best, they have been only marginally effective. Why is that? Well, let me repeat what I said earlier, which is that the idea of them being respected and treated as a co-equal branch is an illusion. Judges, especially on a state's highest court, have high standing at gatherings of their state bar and at meetings of judges in their system, but otherwise they are weak and almost helpless when it comes to commanding respect for their system and the funding that they consider essential. And as important, this crisis is lost in larger seeming problems. One of them is a legal profession problem that gets talked about as if it's separate from the court crisis, but really is part and parcel. And that is the vast unmet need among indigent and economically strained people for good legal representation, for advocacy, as Anna Carpenter of this has written about. There's a widespread crisis as well among recent graduates of law schools who can't find jobs, requiring them to have JDs and allowing them to practice law, including to help meet that need. Just as the adversary system depends on adequate courts as forums for resolving disputes fairly, it depends on lawyers to be advocates in that process. And most middle and low-income Americans can't afford a lawyer, or worse, don't realize that they need a lawyer. In civil proceedings like divorces, child support cases, home foreclosures, bankruptcies, and the list goes on, the number of people representing themselves in court has soared since the economy soured, and there are all kinds of circumstances outside courts where they get steamrolled as well. Research shows again and again that litigants representing themselves usually fare much less well than with good lawyers representing them, and this justice gap, of course, falls heavily on the poor. While the Constitution requires the defendants in criminal cases, certainly felony cases, and now some others, be represented by lawyers, there's no such guarantee in civil cases. And the Legal Services Corporation, which is the funnel through which we fund this kind of representation, has a budget that in real dollar terms is a third less today than it was 15 years ago. In 2013, the last year for which it has data, about 1/3 of Americans qualified at some point for representation by someone funded by the legal services, and about 1/5 of households had incomes at low enough levels so that they always qualified. Half of these people who seek help from legal aid offices are turned away. Let me say that again. Half of the people who seek help from legal aid offices are turned away. Some offices are so understaffed that they must engage in triage, so that in domestic abuse cases, they'll only take them if there's an imminent risk of additional violence. Virtually anyone who's not wealthy is handicapped in our system now. Among all households, only 17% by a New York Times analysis have enough income to meet their regular needs and still save comfortably for the future. That means that 83% of American households, whether they're ones that because of income levels look like they're wealthy, but because of the debt they've taken on are servicing month to month, on down to the poor who qualify for legal services support, they are hard-pressed or very, very hard-pressed to afford a lawyer. And on the criminal side, despite the grandeur of the Gideon ruling 50-plus years ago, and the great principle of justice that it represents, most criminal cases, 95% of them are handled by state courts, and there are only 24 states with a state-funded system of supporting representation for indigent defendants, and some of those are inadequate. And so it's often the case that an indigent defendant will be warehoused for years, not just months, before they get a lawyer who can try to get them out for lack of a speedy trial. And lack of financing is not the only thing going on here. It's contempt for poor defendants, and it's contempt for minority defendants often. The upshot is that the inadequate representation of the poor in civil and criminal matters and of the middle class generally substantially reinforces and is really a part of the inadequate performance of state courts. And next, there's the problem of supply or the plight of recent graduates. A high percentage of recent law school graduates feel absolutely betrayed. In the last few years, only 2/3 of them have been able to get jobs as lawyers. And for more than a few schools, the percentage is much, much worse, 50%. And if you look at schools in the so-called bottom quarter, ranked by U.S. News, it's less than 25%. The rate of employment of this school is notably high and a remarkable accomplishment. The average debt of law students is about $100,000, which most of them took on with the confidence that they would get a good paying job that would allow them to pay it off. And the economic model of the legal profession and the economic model of law schools is just broken. And there are two dimensions of this problem. One of them is just a giant market failure. Imagine if some of those lawyers, young lawyers who can't get jobs, were able to get jobs representing some of the people who need help in civil court, criminal court, wherever. But that market failure is talked about and nothing's done about it. And this leads to the dimension, I think, that matters most to law schools. The consequence of this cascade of problems is that most law schools have lost a sense of what their mission is. They struggle to say what it is. As if that weren't bad enough, we have judicial elections. Judicial elections, since Citizens United in particular, which said that independent spending on elections, that is, addressing issues but not addressing or supporting in particular candidates, was unlimited. And one state court system after another around the country has been changed into an extremely partisan body. 22 states elect judges, 39 states if you count Oklahoma and the others that have retention elections. Retention elections are now the next target for partisan funding. And if we go back to California for a moment and focus again on that moment of payback by the legislature to the court, when the legislature thought it was fine to teach the California Supreme Court a lesson in politics. You have just an inkling of the problem that you have in Michigan and Wisconsin and Florida and Iowa and other states. So in the midst of this problem and the others I mentioned, the state court crisis is eclipsed. It's not talked about. It's not noticed. Everyone involved with state courts knows that they're struggling and failing to do their duty, but they haven't figured out how to get across the depth and breadth of the problem. Well, I want to leave time for questions, so I'll end on a kind of choice of your mood about what you've heard. The most interesting word that I've heard used in a new way when talking with people in preparation for coming out here is the word relevant. This is what Chief Justices most want their courts to be. They want them to remain relevant. And what do they mean by that? They mean that all of the complex corporate cases that used to be resolved in state courts are now being resolved by private arbitration. The major companies in this country, the Fortune 500, the Fortune 250, stay out of state courts because of their unpredictability and for other reasons, unless they have to go there. So relevant means persuading American corporations that they can get more efficient and effective justice in the court system. And that one ambition, I think, has done more to galvanize the Chief Justices than anything else. So in November, a report will come out from a committee under the Conference of Chief Justices. It's a committee that's been led by Chief Justice Thomas Balmer of the Oregon Supreme Court. And I think the most important aspect of its recommendations is likely to be the development of 3 new pathways for how to think about needs of courts. One, a streamlined pathway where 70 or 75% of the cases are likely to go, which won't require much management from judges, which will have a streamlined process where forms will be tools for nudging people towards a resolution, with luck, a settlement. The general pathway, which will deal with cases a lot like the ones that used to be the bread and butter for civil courts, where $25,000 to $100,000 likely is at stake if it's a monetary issue. And then what they are calling the highly managed pathway for complex cases, the kind that are now being handled by private arbitration. Reading memos about the progress of this group does not make the heart leap. This is serious, unflamboyant committee work, and the memos are for people involved with the committee work and not for public consumption, so they contain no salesmanship, no rule of law talk about restoring the state courts to their rightful place of honor. There is no talk about state courts holding great and immensely valuable reservoirs of underlying law. One way to interpret this is that it reflects American legal services in a post-professional era. The Chief Justice's Committee is focusing on performance based on concrete assumptions about what citizen consumers and corporations need, and in this era, the state courts seek to go about their business as efficiently as possible. The business is less glamorous than the business of big law firms, but it's the same measure. And that view is consistent with the idea of state courts fading out, even as they work to repair themselves. On law day, yes, for old time's sake, it will be fine to gush about the rule of law. Otherwise, state courts will be problem solvers and underfunded and apologetic about not being able to do more for citizens. There's another way to think about this fact-based, empirically driven redesign and reform of state courts. We can think about it as an experiment in democratic practice, the kind that progressives encouraged a century ago, work in the laboratories of the states to revive a critical instrument of democracy. And when that revival is proving itself, and with luck has proven successful, the Chief Justices will have a new story to tell, and that story will educate us about a new way of thinking about American democracy. And that approach leaves room for, even invites, lots of fresh empirical work by talented young scholars about what the legal needs of the poor and the economically struggling and others who still look to the state courts for justice, what they really are. To get there, it's essential for governors and state legislators and the rest of us to realize that this is a deep and serious challenge. It's not just for lawyers and judges. It's about our form of government. I'm a sucker for B-movies, and especially about what it means to be an American. And one of the ones I'll always watch when it comes around on cable again is The American President, which came out in 1995. And for those of you who know this movie, you can now imagine Michael Douglas behind this lectern. And in it, as the president, he says in a press conference, everybody knows America isn't easy. America is advanced citizenship. And he goes on and says, we have serious problems to solve, and we need serious men and women to solve them. A bunch of serious men and women have been working hard to solve this one, and they are not going to succeed until the current generation of law students and young lawyers and young law professors recognize that they must exercise their license in advanced citizenship and plunge into hell. The mess that my generation has made of the state courts is really shameful. It's easier for me to see the continuing, if quiet, decline of the courts than the revival, and I'm disappointed in myself that pessimism finds it's so easy to elbow aside optimism in my thinking. But a mess like this is full of opportunity, of painful disruption that creates enormous room for fresh vision and dramatic reform. Everybody knows America isn't easy. We also know the satisfaction that comes from understanding a problem whole and fixing it. And if some of the law students here and their peers take this on, I'm quite optimistic that they will be worthy adversaries for this serious problem. I've got a few minutes of questions if any of you have them. Thank you very much for coming out.
Are there any questions?
Do you know of anyone that is making a difference or doing anything unique or creative?
So I have high hopes for this committee that's working under the leadership of Chief Justice Balmer. I know something about his work and think that he's a man of character and intelligence and a realist, and he's in a court system that has really taken on these issues head on. His predecessor, Paul DeMunis, did that as well. And there's a former Justice of the Colorado Supreme Court, Rebecca Love-Kulis, who has an organization that is trying to be a kind of broker among the different points of view about what needs to be solved. And she understands this issue as well as anyone I've spoken with and is doing great things. And there's a set of rising scholars who are taking this problem on as a sociological and an anthropological problem, not comfortable seeing it the way the more senior lawyers and judges do, but really trying to think of it as addressing a set of human needs. So all of that makes me very interested in seeing what transpires.
2 or 3 thoughts. One, I listened to this, and it's almost indistinguishable from my friends in public education and the crisis they face for the very same reason, an anti-tax revolt everywhere that has defunded state government, particularly when one particular party in state after state after state simply tells everybody every form of government and every public institution is the problem, so you should defund it. Corporations, at least in this state, seem to have no interest in a fair day in court. They go after judges who do nothing more than refer to juries the law that they're supposed to uphold, and when the jury returns a verdict, then they target the judge for defeat in the next election. That keeps happening over and over and over again.
Let me respond to that. I see some significant differences between the response to the state court crisis and the response to the crisis in public education. I mean, for one thing, there isn't the equivalent opportunity for people to create experiments like charter schools that can be the places where new curricula and the length of the school day and different relationships with teachers are experimented with, and then those are imported into school systems. There's nothing like that on the justice side. And politically, that's a very controversial issue. But what strikes me is that it's no longer defined by a right-left disagreement. And those who most dislike it because they believe that the public school teachers are a backbone of the Democratic Party, and they don't want to alienate them. So I see that being different. Your basic point is absolutely right. We have disinvested. Well, we've been so focused on the virtues of the private market rather than its limits for really since the Reagan era. I'm only just now understanding the inequality that the focus on growth rather than distribution of income and wealth has followed from the Reagan policies. And that's certainly a larger issue, but I had more than enough to talk about in 50 minutes. So, other comments or questions?
How much do you think the reduction in the number of lawyers that are or legislators that are lawyers has had to do with contributing to the movement?
I think very significant. I mean, it's really striking that it used to be a point of pride that you would be contributing to your community in a number of ways, and one of them would be to spend some time in that public role. And it's the decline in the number and percentage of lawyers around the country in legislatures is really striking. And that's an issue that's deeply politicized. The Republican Party was much more farsighted than the Democratic Party in realizing the power of state houses. And one of the reasons why there's such a consistent pushback on requests for sustainable or adequate funding by courts is Republican legislatures which have embraced the idea of less government and lower taxation. So I think it's an important insight. Thank you. Anyone else? Well, I think those of you who came for CLE credit have been here for your full hour. So there will be no quiz, no papers required. Thanks again for coming.